Hi folks, this is Dr. Kyle Usrey for Law 518, Constitutional Law. I want to talk to you a little bit about 10th Amendment and states' rights. The 10th Amendment to the U.S. Constitution, one of the Bill of Rights, the last amendment in the Bill of Rights, states the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states, respectively, and to the people. In other words, powers not delegated to the federal government by the Constitution are reserved to the states. The 10th Amendment has often been overlooked by powerful U.S. presidents in the 20th century and early 21st century when they were exercising centralized power to deal with modern problems. However, with the appointment of Justice William Rehnquist, a Nixon appointee in the 1970s, the principles of states' rights were reestablished. There are three constitutional amendments that are often called the states' rights amendments to the U.S. Constitution. The 9th, 10th, and 11th Amendments, which indicate that all non-delegated rights, including police powers and the powers of health, safety, and welfare, sometimes known as health, education, and welfare, those powers remain with the states, as well as an important protection preventing a state from being sued in federal courts, thus a key recognition of state sovereignty and state immunity in our system of government. The 10th Amendment is sometimes seen as a truism, but it defines the role of the states in our federalist system that is at the core of the U.S. Constitution. The Rehnquist Court, that's what it was called during Rehnquist's tenure as the Chief Justice, with Justice Scalia as an Associate Justice at its forefront. This court engaged in efforts at rebalancing federalism, or at least limiting the expansive growth of the powers of the federal government, and in particular the increasing powers of the presidency, or the executive branch. The powers of the presidency have become more and more pronounced lately under something called executive orders that have been issued by Presidents Trump and Obama, almost imperialistically in comparison to what the founders probably envisioned, but this expansiveness can be traced historically back to the days of Teddy Roosevelt and antitrust prosecutions, creation of national forests, and the environmental movement, leading to the U.S. National Forest System, among other things, and to Woodrow Wilson in World War I and the League of Nations in foreign affairs, to then FDR and the various agencies that the executive branch created to deal with the Great Depression, then to the Kennedy-Johnson administrations in civil rights, use of commerce power in expansive ways, and in fighting the Vietnam War, and then to Clinton, then Obama, and now Trump, with continuously growing presidential powers via the use of executive orders to bypass congressional legislation. The powers of the states under the 10th Amendment are often called police powers. That's not just criminal law and enforcement powers, but rather the power to deal directly with something that we've talked about, the health, safety, and general welfare of the public. Broad, extensive powers of local and state government. Later, we'll see that the 14th Amendment specifically extends the coverage of the U.S. Constitution as a rubric or ruler for legality to those police powers as well. States' rights under the 10th Amendment have carried some baggage. In the past, they were known as code words used by Southern leadership in Southern states leading up to and during the Civil War to try to justify slavery and state-authorized racism. Thus, for decades, the term states' rights was hijacked as connoting racial bias and race baiting, if not outright racism. In the early 70s, though, with Rehnquist's appointment to the U.S. Supreme Court, states' rights were reestablished as an important balance against the abuse of power by the federal government. Interestingly, the first case that dealt with this revival of the 10th Amendment was National League of Cities versus Usrey. William J. Usrey was the Secretary of the Department of Labor under the Gerald Ford administration, and he is a distant relative of mine. That particular case, National League of Cities versus Usrey, involved the imposition by federal legislation of wage and labor or fair labor standards, all the way to even regulating the minimum wage of a janitor of the State House in the Capitol building in Cheyenne, Wyoming. And Rehnquist, in writing the opinion, or at least garnering enough votes of his associate justices to strike down that piece of legislation, said that the regulation goes way too far. in impairing state sovereignty and the powers reserved to it under the 10th Amendment. When the federal government starts dictating to the state, and in particular starts dictating the pay relationship of a state employee working in the most important symbol of the state capitol, what to do and how much to pay them, that means that federalism has become unhinged. And so Justice Rehnquist gets the re-recognition of the 10th Amendment as a formidable check and balance against the powers of the federal government, particularly of the president, the executive branch, and its agencies, such as the Department of Labor. That Usrey case actually gets circumvented later on other grounds, but the principles of the 10th Amendment, what we call states' rights or principles of federalism with states' rights, begins to gather momentum, and it continues to gather momentum over years and be applied as a limitation on federal power through the efforts of Justice Rehnquist and then Justice Scalia, and now some of the other conservatives on the Supreme Court. So I wanted to make you aware of that, how important states' rights are today. I would suggest not only for you to look at the textbook and its discussion of that, but to do a little of research on your own, on the current application of the 10th Amendment, because it's often overlooked as to how important that amendment is to our local and state governments, city governments, county governments, parishes, townships, etc., and their sovereignty, and how they are protected against the abuses of federal government exercise of its powers, limited powers. Thank you. Take care. Dr. Usrey.